Real quick introduction. On June 1st, the Virginia Supreme Court issued its fifth emergency judicial order. So I previously recorded the presentation that will follow. The timeline and the discussion there are still valid, but just keep in mind we're talking about a fourth judicial order. The fifth one just came out today, and then I'll have some new remarks at the conclusion of our pre-recorded segment on the governor's executive orders and the orders from the Virginia Supreme Court. This information will be foundational to our next two presentations regarding custody and child support. On Thursday, March 12, 2020, the Governor of Virginia issued Executive Order 51. This declared the state of emergency and activated the necessary plans and agencies to address the pandemic. The order is to remain in effect until June 10, 2020, unless modified. The legal authority for this order derives from Article 5, Section 7 of the Constitution of Virginia. The order cites several statutes in the Virginia Code at Title 44, Military and Emergency Laws. So that was the governor and the executive branch. In response, on Monday, March 16th, the Chief Justice of the Supreme Court of Virginia, Judicial Branch, issued an order declaring a judicial emergency. This was the first of what would be 4 total orders and 1 amendment as of the end of May 2020. It affected only state, district, and circuit courts. Federal courts and appellate courts are separate. I was in court for a hearing on March 16th as this was all falling into place. The other counsel and I needed to docket a hearing, and the clerk basically said there was nothing available until mid-May and then maybe. Well, the emphasis was on maybe, as the temporary hearing that we wanted in May ended up being joined to the final hearing in July. So this is the kind of impact that the emergency is having. The first judicial emergency order was to be in effect until April 6th, a 21-day term. It suspended all non-essential and non-emergency court proceedings. So for family law litigants and practitioners, that means no divorce trials, no pendente lata hearings, etc. Now, in our next 2 videos, we're going to come back and talk about the impact this has on custody and support matters. With regard to this matter on the order, the criminal matters and the emergency protective orders stayed on the docket as those were deemed essential. Now, this emergency order described the measures that the courts were to follow. Noteworthy here is mentioned that all deadlines were tolled, T-O-L-L-E-D, and extended for 21 days. For family law litigants and attorneys, this impacted when answers to complaints are due, when discovery deadlines fall, as well as scheduling orders. Also, telephonic and video technology was authorized for all necessary hearings, trials, etc., including arraignments. This, I believe, will play out to materially change the practice of law as the bench and the bar becomes accustomed to the technology. The legal authority for the court's actions is at Virginia Code Section 17.1-330, a declaration of judicial emergency. If you look at the statute at paragraph A, it provides that emergency may be declared when a defined disaster threatens the operations of the court. Now, if you look at the court's emergency orders, you will note that they have a peculiar organization. That's to meet the requirements that are laid out in paragraph B, which describes the contents that must be specified in the orders. Finally, on paragraph E, it provides for the duration of the order, and this is where the 21-day term comes from that we're talking about. However, on several of the telephone and web conferences that I've attended, participants have noted that there is a provision that allows for the order to be effective during the duration of a health-related event. So let's go back to our timeline. So far, the governor issued his order, the Supreme Court issued their order. Now, Executive Order 53 comes out on March 23. This is the one that affected businesses and schools and so forth. Then on March 27, the Supreme Court, all justices unanimously, issued a second emergency order extending the April 6th term to April 26th, another 21-day term. Additionally, the deadlines, the time schedules, filing requirements, including statutes of limitation, were told and extended during this order. Interesting here is that all matters except emergencies are continued. Not continued as in proceeding to occur in the normal course of business, but continued in that they are delayed or deferred to a later date. Now, this is huge. The courts do not have the available docket space to move weeks of cases to later because there will be later cases come in that need that time. These orders were blanket orders in that they uniformly applied to all courts, but they did authorize local judges some discretion to vary the requirements or what they could choose to do. Keep in mind that this is only about 11 days into this. The courts were and they are making substantial changes to accommodate the public. For example, in addition to remote hearings, there's a provision for e-filing or even for drop boxes so the pleadings can be filed. Executive Order 55 issued on March 30th. We will discuss this order in more detail in the next video as it addresses travel for court-ordered parenting time. Now, Executive Order 53 was then amended on April 15th. It essentially extended the covered period from what was April 23rd now to either May 7th or June 10th, depending on the matter. Turning back to our judicial orders. Judicial Order number 3 comes out on April 22. The emergency periods get extended another 21 days now to May 17th. Some things to notice here. The first two orders are still in effect and they're included or incorporated in the third order as if they're a part of that third order. The tolling period continues in district and circuit courts. The courts may hear non-emergency matters by two-way communication systems. Critical here upon agreement of all parties, attorneys, and witnesses. Now this is unusual. First, it allows witnesses to decide whether or not a hearing will proceed. Second, it has to be by unanimous agreement. If a party has potentially violated an order or refused to provide support, etc., why would they agree to a hearing to end their violation or suspension any sooner than necessary? These issues, that is the tolling and the agreement requirement, as well as electronic signatures and filing, were concerns of the bar. There was a joint letter from bar leaders to the Supreme Court asking about modifying or accommodating these provisions. For example, some courts were accepting signed electronic PDF documents. Other courts were insisting that there be at least one wet ink signature on a paper document. On May 1st, the Supreme Court clarified the provisions with regard to speedy trial deadlines. This is an important issue, but out of the scope of family law matters. The fourth emergency order comes out on May 6th. It provides some very useful insight into how the courts are being impacted by the emergency. For example, in the General District Court, there were 2.8 million filings, 3.4 million hearings, that is 65,322 hearings per week in year 2019. Particular to family law, the JDR courts were doing over 20,000 hearings per week, the circuit courts almost 22,000 per week. So at this point, the courts have been closed about 7-ish weeks, and that's a lot of hearings to be moved. From mid-March to mid-May, the JDR court continued about 125,000 cases, in the circuit court about 135,000 cases. Now the circuit courts hear a variety of cases other than family law matters, but on the JDR side, that's almost entirely a child, a family, a spouse, etc. cases that, i.e. individual people that are being affected by this. Every week the courts are closed adds another 18 to 19,000 new cases to the JDR or the circuit court docket. This is further compounded by the shortage of court clerks to process the cases. The state budget had been allocated to remedy that, but those monies have been frozen. In this fourth emergency order, we did get some relief. The tolling of discovery that was cast in with all the other suspended deadlines was addressed separately. Now, all discovery issued with the deadline during the judicial emergency is due within 21 days of May 18. The next noteworthy content of this fourth order is that the decision-making authority is now delegated down to the individual courts. Previously, the central authority of the Supreme Court was directing the policies of the lower courts. This fourth order now delegates decisions down to the local level so that courts can adjust as to their particular circumstances. There's language in the order to the effect of judges are charged with or clerks are charged to. There's a provision that says transition should be accomplished by the chief judge. So this order also provided for electronic or scanned signatures. So at this point, some of the bar's concerns were addressed and resolved here, but what about the unanimous consent for hearings? Well, on May 12th, some amendments to paragraph 4 of the fourth order came out. Quote, "It is not necessary for a party to obtain the agreement of any other party to bring a pretrial motion." End quote. So there is now the last resolution. In closing, the bench and the bar have made significant changes to the profession that is not necessarily known for its cutting-edge processes. I mean, who else cites authorities from the 17 and the 1800s as persuasive today? Nonetheless, remote hearings and trials are occurring. Pleadings are coming in by electronic filing with scanned signatures. However, given the rates at which different locations are entering from phases 0 to 1 to 2, etc., it will be particularly important to check with your local court frequently to stay informed of their local developments. So there's our foundation as to where the courts are today. Next, let us look at matters of custody and support in light of this. As I said earlier, this June 1st order just came out today. This video will be released on June 2nd, the Tuesday. And so we'll take a look at it real quick here. And so essentially, the historical timeline that I went through earlier remains in full force and effect. And then this fifth order continues that on May 26, 2020, the governor entered executive order number 63. That became effective on May 29th. Among other things, it required, with some exceptions, that face masks be worn inside buildings. So executive branch through the governor issued that order, and then the Supreme Court came out now with its fifth judicial emergency order. Paragraph 1 provides that the statute of limitations, as well as case-related deadlines excluding discovery. So again, we have the exception for discovery. That timeline continues to run. Will be told during the period of judicial emergency, which is now defined as March 16 through June 28. So that's the big extension we came here, is that we have been going in 21-day increments. And so we've added another increment with this June 1st order that will now be bumped out to June 28. Consistent with the court's fourth order, in all civil cases, jury trials are currently suspended. Deadlines and obligations arising out of Part 4, which is the discovery, is not told. So as I said, the discovery will continue. Additionally, the court may impose and enforce case-related pre-trial deadlines. So if there are scheduling orders in a case, you may still have to comply with those, even though your trial may fall within this period or fall just beyond the period. And in paragraph 2, it provides that courts shall continue to prioritize emergency matters, which would include arraignments, bond hearings, protective orders, and so forth. So those will continue to be heard, as well as emergency custody matters that's relevant to the family law litigants and practitioners. The court shall, or should continue rather, to conduct as much business as possible by means other than in person. Notwithstanding any of the foregoing, with regard to conducting hearings by video or telephone, all courts may hear in person non-emergency matters if it is safe to do so. So again, discretion at the local court. With regard to motions, as we talked about earlier, it is not necessary to obtain the agreement of the other party. Again, this order charges that all court and security personnel are to address safety concerns and do the necessary screening and so forth for the safety of the public in the courthouse. Paragraph 7 of this emergency order, the fifth one, does provide that all persons over the age of age 10 entering the courthouse must wear a face covering that covers the nose and mouth. There are some exceptions if people have conditions that would make that unsafe for them to do that. Additionally, continuances and excuses for failure to appear will be liberally granted. So if for some reason you're not able to attend a hearing, either you can ask in advance for a continuance, or if you're not able to there at the time, you can be excused for that. Paragraph 12 says that all civil and criminal jury trials are suspended. No jury trials shall occur in the Commonwealth for the duration of this order. So for those who are concerned about jury duty, you have a reprieve here for the next couple weeks on that. Now be aware that all jury trials scheduled for a date after June 28 is subject to further period of suspension if the declaration of judicial emergency is extended. To the extent that this fifth order is different from the earlier four orders, then the terms of this order will prevail. So essentially the same substance in the fifth order, just extending the duration that's covered by the emergency declaration.